David Shearer.
Mr Speaker, as the Leader of the Labor Party, Andrew Little, mentioned, the Labor Party will be supporting this to the Select Committee, where it will, as the Attorney-General just said, go through some fairly significant examination in terms of its suitability and its balance. And I too would like to acknowledge the very different approaches that have been taken both to this bill and to the Foreign Fighters Bill in 2014 in terms of a collaborative approach, because a bipartisan and a collaborative approach on this sort of issue is absolutely essential. First of all, obviously, the legislation is going to survive various parliaments into the future and needs to be future-proofed. But secondly, because it does some of the most fundamental, looks after and protects some of the most fundamental privileges that we have as New Zealanders and as citizens of this country. It essentially protects our freedom to live peacefully, to live in security, to lead prosperous lives, alongside the freedom of our ability to have privacy and a degree, and certainly a large degree, of ability to operate with that privacy. Sir, I mention the collaborative approach that has been taken now because I think, unfortunately, 2 or 3 years ago, when we first had the GCSB bill that came up, you'll remember the farcical fiasco around Kim.com at the time, and the way that the government pushed that piece of legislation through with the acquiescence or arm twisting of Peter Dunn in order to get that through, meant that I think we did an enormous amount of damage to the way that New Zealanders perceive our intelligence agencies and the confidence that they had in our ability to conduct those sorts of activities. So that the means and the process by which it's going through now has a very big bearing on the acceptance that the public will have in terms of the outcome of this bill. It was our argument back then in 2012, 2013 that we needed a comprehensive review. We looked across at Australia, who had already 2 comprehensive reviews by that stage, and we have still had 4 fragmented pieces of legislation, much of it had come out of the Cold War, completely unfit for purpose, and not doing what it should and what it should have and meant to have done. So, sir, the Cullen Reddy review was a very welcome step. They put out, I think, a very good, a very balanced report, and it has stood us in good stead now in terms of taking that review, that report, and moving it into the legislation and the new bill. But as with legislation and with bills, it puts a greater onus to get it absolutely right, absolutely accurate and robust, perhaps even more so than a review which can be at least slightly ambiguous or perhaps a little more loose than a piece of legislation. Sir, what we have now is a bill which at first reading anyway, at first look at it, looks good enough certainly to support, but it certainly throws up a number of areas which we're going to have to take a better look at. And that will mean a number of expert submissions from the Privacy Commission or the Law Commission, etc., who had spoken to us and come to us in the Foreign Fighters legislation, to really look at what we have before us, because we have some pretty thorny issues. Andrew Little mentioned the definition of national security. This is, in a sense, at its essence of the bill. What is national security? What is this bill trying to achieve? If we don't get that right, we could lean more to leniency in terms of what the agencies are able to do, or constrict them unfairly in terms of being able to provide the sort of protections that we want. One of the issues, sir, second issue, is which has been mentioned and was predictable, I suppose. It was the issue of the GCSB having the ability to spy on New Zealanders. Sir, there are a number of issues and problems around the GCSB's current role and the way that it operates. For example, if we had a New Zealander, for example, who was taken hostage in another country, and we heard a New Zealand telephone being used and emanating from that country, and we wanted to know what was being said on that telephone because it might have pertained to the plight of that hostage, GCSB would not be able to listen to that telephone because it is a telephone of a New Zealander. Likewise, if there was if one of our New Zealander was overseas and became a foreign fighter, once again, we thought that person might have been using their telephone. Again, we would not be able to listen in to that particular call to give us information on both that person or, in the previous example, on the hostage, because GCSB is unable to access those records because they happen to be a New Zealander. So that's patently a ridiculous situation to be in. And so what the review has come up and what's reflected across in the bill is the fact that, yes, GCSB can look at for example, the phone records of New Zealanders, but it has to be done in an exceptional way at what we now call a third tier level of clearance, which means the Attorney General, which means the Commissioner of Warrants, and obligatory examination of that warrant by the Inspector General of Intelligence, and looking at the mechanism of that. It's not a large number, but what we wanted to do here is to give our intelligence agencies, in a sense, the broadest ability to operate, but with the tightest degree of scrutiny, so that they have the range of powers that they need, but they can only use them under very specific and exceptional circumstances where our national security or somebody's personal security is dependent on. And I think that's the balance that this bill has to try and achieve when it goes through into the Select Committee. Andrew Little mentioned as well the role of the Intelligence Security Committee. This is a particular issue that I've talked about several times in the past. And that is that the Intelligence Security Committee, if you look at the various degrees of oversight, there's the operational oversight which happens within the agencies, and the operational protocols that are in the agencies, which have been very much tightened over the last few years. The judicial oversight, which includes the Commissioner of Warrants and the Inspector General of Intelligence, which is essentially the second level, and the third level, which is the political oversight, which is contained in the Intelligence and Security Committee. Currently, 5 members chaired by the Prime Minister. In other jurisdictions, that committee, similar committee, is not structured in that way, but has senior members of former members, perhaps, of government, former ministers, members of the opposition in that committee, where it is not chaired by the Prime Minister, which has the casting vote, and therefore, in a sense, has a conflict of interest, because the agencies themselves report to, ultimately, the Prime Minister, and the Prime Minister then has the power of oversight. I mean, we don't have the Health Minister, for example, sitting in the Select Committee, the Health Select Committee, looking and passing judgment on what her health ministry happens to have done. So or his ministry. So getting that balance right in the Intelligence Security Committee would mean that we want to look at overseas examples, the Australians, the Brits and the Canadians in particular, and see how that works out. Likewise, a fourth issue that perhaps I'll raise as well, which is on the access to databases. There should not be a general access of databases by agencies, but it should be done on the basis of what they need to know for a specific purpose, and that it protects the privacy of New Zealanders. And that, sir, when it comes down to it, is where we need to find the balance in the Select Committee, and before we refer this bill back to the House again. So I think I'm confident that this committee can do it. I think we've built in a sense, the degree of collaboration and bipartisanship in the past. We will be looking at this very intently. We will scrutinise it, as an opposition should, very, very thoroughly. But at the end of the day, I hope that this will end up being a piece of legislation that will stand New Zealand in good stead. Thank you.
Mark Mitchell.